Okay, right. Well, I think we'll kick off. Welcome everyone to the Mills and Reeve seminar on financial resilience. Speakers today are on your screen at the moment. A couple of housekeeping points before we start. This session will be recorded, and a recording and the slides will be available to all the attendees and will be sent out to you after today. There will be 4 presentations today. It should take around about 45 minutes, and there will be time for questions at the end. So please do put any questions that you have into the chat function. We are aware this is quite a sensitive subject, so please be assured that only the panelists will be able to see your questions, and we will, of course, anonymise the questions when we mention them. Equally, if you would rather just send questions to any of the speakers today, then please do feel free to do so. Their contact details can be available from the QR codes on the screen. Okay, we can go on to the first slide, Sarah. Oh, and the next one. Thank you. So this is going to be the first in a series of webinars arising from the work of our Financial Resilience Task Force. And as a firm, we've increasingly been advising on some of the consequences of the current challenging financial circumstances, but not just the purely financial. There's an overlapping areas such as regulatory, real estate, employment, pensions, just to name a few. And the task force has been bringing together lawyers across all of those areas to approach the challenges facing universities in a more holistic way. So I say this is the first in a series of webinars. Would be really interested to hear from you if there's any of the areas we explore that you'd like to hear from us in a bit more detail. So what we won't be doing today is going into the root causes of the financial instability. They will all be very well known to anyone on this attending this webinar. But I think as the media and the government and the regulator increasingly focus in on the financial position of universities, and there's a lot of talk about market exit, failures, bankruptcy. What we wanted to first of all do today is strip away some of that noise and actually look at what the actual legal position is for universities and where we think the regulatory system might go. So the 4 speakers today, firstly will be Matthew Howling in our financial team, who's going to look at the legal ways in which a university could become insolvent. Neil Smith, who's a partner in our restructuring team, who will look at whether or not a special administration regime would help or hinder the sector. Richard Sykes, a specialist educational partner, will look at the role of the OFS, what powers they have, what powers they don't, and whether they're using the ones that they do appropriately. And finally, Poppy Short in our corporate education team will look at whether or not mergers can ever be an answer for universities in financial distress. So I will hand over to Matthew and the first session.
Thanks, Sarah. Welcome, everybody. As Sarah said, I'm going to be looking at how an HEP would actually exit the market. And my short and rather flippant answer to that is not well. As we'll explore in the next few minutes, there is a great deal of uncertainty as to what insolvency processes would apply. And the consequence of that uncertainty is the prospect of a disorderly exit and uncertainty for students, for staff, and for creditors. So let's dig a little bit deeper into my rather flippant, not well comment. But to answer that question as to how an HEP would exit the market, because there is not one sole insolvency regime, we have to think about the constitutional structure of the different types of HEP. So if I could have the next slide, please. So in HEP, in higher education, we're faced with a whole host of different legal structures. And I'm only going to concentrate on a few of them today because there are a plethora. But the most common, arguably, are royal charter corporations, higher education corporations, and companies. So with royal charter corporations, that's the original form of incorporation, if you like. So where a monarch seals a charter, that brings the corporate entity into being. Probably the next most common are higher education corporations. So these are the so-called post-92 universities that owe their incorporation to the Education Reform Act 1988. And finally, I'll touch on these only very briefly, are companies, usually companies limited by guarantee in the HE space. I won't say too much about these because they are companies in a Companies Act sense. We're pretty confident about the insolvency processes that would apply to them. So for the rest of this talk, I'm going to concentrate particularly on Royal Charter corporations and higher education corporations. So if I could have the next slide, please. It's quite a busy slide when we look at the legal processes with lots of crosses and only a few ticks. But the basic takeaway from the slide is that when you're dealing with Royal Charter corporations and higher education corporations, we think the vast majority of corporate insolvency processes will not apply. And in fact, what you're left with, and it's really trying to piece things together through a mixture of old case law and frankly educated guesswork, is we're left with a position whereby we think Royal Charter corporations can probably be wound up as unregistered companies. There is old case law, Victorian case law, to suggest that's the case. Now that case law is old, as I say, and it doesn't apply necessarily to charities. A lot of the cases related to trading corporate bodies that were established by charter. But we think using that as a precedent that wind up would probably apply. Similarly, with higher education corporations, we think possibly a court would say, if a winding up position were presented by a creditor, then the court would probably say, well, yes, I have inherent jurisdiction to listen to this case. So, as I say, it's all very much sort of pieced together and rather flimsy, but we think that wind up or compulsory liquidation is a possibility. Now, that has its own consequences, because compulsory liquidation, winding up a corporate entity, is a terminal process. What do I mean by that? Well, there is no mechanism that exists for an insolvency practitioner to trade a business through a wind up, through a compulsory liquidation. So automatically you're looking at something that is terminal, where there is an immediate shutdown situation. And for HE, that would the consequences would be frankly catastrophic. Now, some of you may be aware that in recent cases, in recent rare cases of Carillion and Thomas Cook, a liquidation process was used, which involved the official receiver effectively acting as a public liquidator, if you like, working alongside a special manager. And they were situations where there were a lot of contracts to wind down or high liability. In the case of Thomas Cook, you had to repatriate customers. You could potentially see a situation like that being used, or that process being used for HE, but it would involve creditors getting the government involved. So it's unlikely that a government of the day would be quick to do that because of the PR repercussions, quite frankly, and also I suppose the perception that they would be seen as somehow bailing out the sector. So it is an option, but it's an expensive option and an unlikely one. So what we're left with, as I said at the beginning, is this possible terminal process. Now, just very quickly touching on enforcement, we also think that floating charge security is not something that can be given by Royal Charter corporations or higher education corporations. So in terms of security and enforcement of security, what you're effectively left with is charges, fixed charges, legal mortgages over land, which, as we'll see in a moment, has consequences for how creditors are behaving in this sector. So then what are the practical implications of this cliff edge, this terminal process that I've been talking about? Well, can we go back to the next slide, please? Can we go back to the previous, sorry, can we go back to the previous slide? So just while the slide is coming up, the practical implications of this, of only having a terminal process. So the next slide, please. Thank you. So effectively, we have this uncertainty, and to give the OFS some credit, and I don't give them much, they've at least tried to address their mind to the sort of planning that would have to be involved if we were in this terminal situation. So the issues to consider would be things like teach out, student transfer, making sure students have a formal record of achievement if they do transfer, dealing with student complaints, information, advice and guidance to students, and then archiving arrangements so that there is a permanent record of their sort of previous exam results and previous achievement. So the OFS have started to think about this in terms of market exit plans. But what I would say is that a plan is no substitute for a legal process. And also, while they attempt to provide a solution, I think, as I say on the slide, they create a huge burden on providers at the worst possible time, and also query whether market exit plans are actually binding. So if a creditor did try to wind up one of these institutions and a liquidator was appointed, would that liquidator really be bound by a market exit plan? It seems unlikely, particularly given that the legal obligations of a liquidator are towards creditors as a whole, not specifically to students. Um, and the big elephant in the room, of course, with market exit plans is who funds them. It's all very well having a plan, but if there's no money to see these things through, they're not really worth the paper they're written on. The other thing I would throw into the mix is one thing we have seen with the OFS's requests around market exit plans, is requests around struggling institutions effectively contacting their competitors, talking about either merger or transfer of students, which sounds very laudable. But just consider for a moment what would happen if those discussions leaked, they became public. Well, you're in a situation where you're just making a bad situation worse potentially. And also, if the university in question is distressed but not legally insolvent, then those discussions may not be in the best interests of the charity, because you have a struggling institution that is forced to talk to its competitors. Well, that's not good in a competitive environment. And as trustees, they have duties to act in the best interests of the charity. Well, if the charity is still continuing and at that point in time surviving, to then be talking to your competitors is not a good place to be necessarily. So there's some of the practical implications. If we can move on to the next slide, I'd like to just sort of touch on the if you like, the social aspects of this, with the sort of behavioural aspects that are driven by this uncertainty. Now, there's probably one benefit in all of this, is that the uncertainty that I've talked about probably leads lenders to the sector to be more cautious. And what I mean by that is that they won't necessarily rush in to enforce, say, security. So they'll probably tread more carefully. So there's a little bit of forbearance that hopefully the sector can look to because of the uncertainty. But because there is this lack of wide-ranging security that I mentioned earlier, with land security being the only sure form of security in the sector, then there's a risk of what I call there a land grab. In other words, your creditors, your lenders seek to obtain legal mortgages, legal charges over property because it's the one sure form of security. Now, that affects not just lenders, but also pension funds. And we've seen situations with the USS and with other defined benefit schemes where there's this desperate desire to put themselves into a secured position. So you have what I've described there as an arms race, where everybody tries to take land security. And it sort of becomes its own mini industry in itself. It's an end in itself, where everybody looks to take security, to be seen to be secured in the sector. So you can rapidly see that you get to a kind of race to the bottom type situation. Now, where is the OFS in all of this, and what behaviours do we see from the OFS? Well, the OFS has said quite publicly, and there's a quote there from the House of Lords Industry and Regulators Committee. It said quite publicly, well, frankly, we don't have the tools for the job. And that would be great if the OFS sort of acknowledged that and frankly, let institutions sort their own problems out. But what they seem to do is to ask for more and more information, to demand a higher and higher burden when it comes to market exit planning. And they do this, frankly, at the worst possible time for institutions. So they're asking for data, they're asking for plans at just the point in time when the focus of the executive team, when the focus of the institution should be on turning the business round, not seeking to produce more and more paper for the OFS to not really do anything with. And the final point I would make is that this uncertainty feeds into the behaviours and the challenges for the governors, for the charity trustees. Because of the uncertainty, it's uncertain whether the Insolvency Act provisions around, for example, directors would apply. As many of you know on this call, there are provisions in the Insolvency Act to deal with misconduct and wrongful conduct by directors of companies, so wrongful trading, fraudulent trading, and so on. So all of that to protect creditors. We don't know for certain whether that would apply to charity trustees. So our advice tends to be in these situations that charitable trustees have to act as if these duties apply. So then duties on insolvency may shift to having to act in the best interest of creditor, creditors rather than acting in the interests of the charitable objects. So I hope I haven't depressed you too much, but that's the world of uncertainty we are facing at the moment. And I'm going to hand over to Neil Smith, who's our head of restructuring, to look at whether a special administration regime will solve some of the problems I've been talking about. Thank you, Neil.
Thank you, Matthew, and good morning, everyone. As Matthew says, I'm a partner and head of our restructuring insolvency group at Mills and Reeves. So I'm going to be talking about whether a special administration regime may be, to a certain extent, the answer here, and I'll also explain what I mean by that. Before I get into that, though, I think it is worth setting the context and just following up from what Matthew has said. So I get asked to go and advise and have advised various trustee boards of HEPs of various different structures, but as Matthew has said, most of them are not companies, in relation to financial distress that they may be facing at any particular time. So Matthew has talked about the different structures that you have for HEPs and the different insolvency processes that are available, although more accurately, it's probably the insolvency processes that are not available. And that is part of the problem, because the processes that are not available are the ones that you would really want to use in relation to an HEP that needed some kind of protections for an insolvency regime to achieve whatever they are trying to achieve. As Matthew said, fundamentally, at the moment, in relation to a non-corporate, you are looking at liquidation, which is a terminal process, or fixed charge receivership. Neither of those two are real solutions as insolvency processes. And Matthew's also talked about the nature and security enforcement options. But I think one of the greatest challenges is advising the trustees. As Matthew touched on in his last slide, when we come in and advise trustees, we are saying to them, you have duties as a trustee of a charity. You may or may not have duties to the students under those charitable objects and in relation to your position as a trustee. You are not a director of a company, but you may be subject to the same companies and insolvency regime on the basis that your entity could be wound up, as Matthew said, as an unregistered company. So I come in and talk to boards of trustees and talk to them about some very serious issues for them, including personal liability, but I'm unable to give them clear advice, which hopefully is not a reflection on my approach to these situations, but is more a reflection of the fact that the law is very unclear. And I think that is very unhelpful, because you are talking to people in very stressful situations. You are talking to them about personal liability, and yet you're not, as I would hopefully be able to do in a company situation, give them any clarity as to what the rules and regulations are and how they should be followed. So as Matthew's touched on and set out in the middle of that slide, there is no duty to students under the insolvency legislation. And we found that in relation to a provider called Aura, who I acted for a couple of years ago, which ended up going into compulsory liquidation, which was a company limited by guarantee, and therefore the insolvency and companies legislation did apply. But whilst the company and insolvency legislation applied, none of that legislation included any duty to students, and that put the trustees, even in a corporate situation, in a very difficult situation. So you are trying to help the trustees balance those three duties set out on the slide without being able to be clear as to exactly what the legal position is, which is obviously very unhelpful. And Matthew has touched on the other stakeholders that you have out there that the trustees ideally are trying to keep happy, along with creditors, and some of them might be creditors as well. DFE, Office Students Charity Commission, who may be overseeing from a regulatory point of view, and also the interaction that you are having with pension providers. So that is the situation that we are finding at the moment when we are coming across situations where we need to advise trustees of HEPs who are in a certain amount of financial distress. So if we could go on to the next slide, just moving from that. This is why we think a special administration regime might help in light of that context. So you may or may not be aware of the special administration regime, which came into force about 5 years ago now in relation to the further education field. In that field, again, you had a number of entities who were not operating as companies, and therefore you had a number of similar issues in the FE sector that you have in the HE sector in relation to what duties apply, what insolvency processes are available, what enforcement options are there for secured creditors, which Matthew has talked about. Now, the special administration regime in the FE sector, and we believe that it would assist also in the HE sector, fundamentally breaks down into two parts. The first part is corporate governance, which is where I think the special administration could be of most use. The second part is to introduce an administration process that would actually be available for non-corporates. Why is an administration process useful, particularly in light of what Matthew has said, and as I've briefly described, that liquidation is really the only option out there? Well, administration is a process that allows an administrator to trade a business, in this situation an HEP. And what it also does is it creates a statutory moratorium that prevents creditors from enforcing their rights, so effectively gives an entity some breathing space. Now, there are challenges around administration, as there would be in any sector, in relation to funding and process. And, could you realistically use a special administration to trade an HEP out of its difficulties? I think is debatable, but at the very least, it is a process that you could use with some protection to allow a teach out, to allow movement to students in a manageable way, rather than an unmanaged close down like we had on Aura. However, I think where the special administration regime has been of more use in relation to the FE sector, and so far 5 years that it's been enforced, there have been two special administrations, but effectively in relation to the same two colleges, Hadlow and West Kent, is actually, I think there's more use on duties, because what the special administration regime has made clear in the FE sector is that the companies legislation and the insolvency legislation apply to entities operating in that sector, whether they are companies or not. What it also provides is that there is a specific duty to act in the best interests of students. So that is above and beyond the companies and insolvency legislation, and makes the position clear for trustees. So I think that is two areas of corporate governance where it would make the situation much clearer for trustees of HEPs to understand in a financially distressed situation how they should be proceeding. Lastly, and you may say, and hopefully I can answer it on the last slide, it would, as well as providing administration moratorium for the providers, it would also provide an enforcement route for the secured lenders. So if we move on to the next slide, I will try and explain why that should be relevant to you. So as the question says on the slide, I am involved in an HEP. We are not in financial difficulty, and therefore, why does any of this have any relevance to me? Well, as I've said, I think just because an entity is in financial difficulty does not necessarily mean that it needs to go into an insolvency process. But I think it would benefit all trustees, because at some stage they may come across a situation where there is a financial resilience issue, to understand with some clarity as to exactly what their roles are regarding the interaction between them as a charity trustee and the interaction of the companies and insolvency legislation if they apply. It would also help the trustees, I think, from a charitable objects point of view, to understand that they have a duty to the students, and therefore if they are taking actions in the best interest of the students, they will be protected under the legislation, which currently they are not under the insolvency and companies legislation, as I've said. It will also be better for the students in financially distressed situations, because they will know as a matter of law that the trustees have a duty to them specifically, rather than just as one class of creditor, and that the trustees will need to bear their interests in mind. It is hoped, and this is what Matthew has touched on already in relation to the current regulatory position, that if there is a clearer position both for trustees and available insolvency processes that could enable for a market exit, that HEPs will benefit hopefully from less regulatory oversight. In an assignment that we've recently been involved in, the OFS has put a very heavy burden on a provider to provide a lot of information at a critical time when they are looking to negotiate with lenders, etc. And that has not been overly helpful. But as Matthew has touched on, that a lot of that has been driven by the fact that there is not a clear insolvency process available, if needs be, to achieve a market exit. But I think one of the most important points as to why this is relevant to you is to the extent that you have bank debt or would like to obtain bank debt. I think a special administration regime with a clearer line to enforcement for lenders would lead to a clearer line to funding. That is not to say that lenders out there are looking to enforce their security against universities, because there are various PR reasons why that is not going to happen. But when those education specialists at those lenders go and talk to the powers that be at those banks in relation to how they get their money back and tell them that there is not currently a clear path, that is not going to lead to an enthusiasm amongst the banks to be lending money to this sector. And I think if there is a clearer line for recovery, then hopefully there is a clearer line for funding, as I say in the slide. So that is enough for me. If we go to the next slide, I will pass over to Richard Sykes to talk about the OFS's role.
Thank you, Neil. I think we all know that the Office for Students is the regulator for higher education providers who are based in England. And in the next 10 minutes or so, we'll take a look at what the role is and say something of our experience interacting with it on behalf of clients, because that's one of the main things I do as an education specialist, is support higher education providers on their interactions with the OFS. Now, the OFS has said many times that its primary focus is the student and has based, I think, that raison d'etre on the name it was given, a sort of nominative determination, I suppose. But what does the law say about how it should act? Well, that's what I've set out briefly on this slide. The Higher Education and Research Act 2017 created the OFS, and that act gives the OFS a number of functions, which such as things like establishing and maintaining the register of higher education providers and assessing, or at least arranging the assessment of the quality and standards applied to registered higher education providers. The Quality Assessment Committee, the OFS is required to establish and maintain that. And more recently, and coming into force in a country near you, is the obligation on it to promote the importance of free speech and academic freedom in the provision of higher education. But in doing all of these things, all of these functions, the OFS is required, i.e. it must, consider those matters which are listed on the slide. And first, the Act, I think it's worth observing that the Act doesn't create a hierarchy among these factors. They're all equals, if you want. You'll also see that the word student does not appear that often. And although students are very much factors in 3 or 4 of the considerations, including the one with the deliberate typo of choice, which should of course be choice, the OFS is required to promote quality choice and opportunities for students, as well as encouraging competition where that is in the interest of the student, not just the student though, also the employer. That might follow that might recruit that student subsequently. And these factors that the OFS must consider are inescapable for it. It should have all of those in the forefront of its mind when it's engaging with higher education providers and exercising its regulatory functions and engaging in its regulatory activity. So next slide, what does the regulatory framework say about so I've just realized I was looking at a different slide to the one that was in front of you. So that choice comment might have been misplaced, but there we go. What does the regulatory framework say about about engagement with providers in connection with market exit, which is what we're looking at here, I suppose? Well, first we have the Student Protection Plan, which is required under condition of registration C3, and all institutions are required to have that. And secondly, the OFS uses student protection directives under condition of registration C4. If you click the slide, please, Lucy, there we go, lovely. One of the Student Protection Plan is one of the documents that one needs in order to achieve registration with the Office for Students in the first place. And they're usually drafted at a time when the prospect of ceasing to deliver higher education is very remote. They're usually pretty vague and tend to focus, I think, on how one might cease to deliver one or more programs or courses. They don't tend to consider full market exit, as it were. So they are operating at a pretty high level. By contrast, a student protection direction is the tool that's used by the OFS when a provider gets into financial distress. And the first thing I observe on the slide in particular is that the OFS has set a condition that needs to be met before it can issue a student protection direction. And that is that the OFS must reasonably consider that there is a material risk that the provider will or will be required by the operation of law, fully or substantially, to cease the provision of higher education in England. And thus, as a matter of regulatory practice, and I would argue a matter of law, the OFS should not exercise this particular intervention, the student protection direction, unless the full set of those conditions exist. Now, the judgment as to whether they exist is the OFS's, but it needs to be a reasonable conclusion that it reaches. The condition of registration itself lists out a number of things that the OFS can do and or require a higher education provider to do under a student protection direction, and these are pretty widely drawn. They include things like producing a plan containing student protection measures, implement specific student protection measures, do or don't do certain activities, and those can be consequential, ancillary, or incidental actions that, as the OFS considers reasonably necessary for ensuring that a market exit plan and student protection measure are in place. Now, the OFS expressly says that student protection measures, so these are things that the OFS can require an institution to produce a plan for, once those conditions on the slide are ruled to be in existence. Those things are setting out a teach-out plan, arranging for student transfer to other institutions, having arrangements in place to ensure that exit awards and unit certification are achieved, providing information, advice, and guidance for students, having a complaint handling system, and perhaps most interestingly is making arrangement for refunds and compensation, specifically returning fees and other costs that have been incurred and offering compensation to students to cover financial costs caused by market exit, which is quite a significant series of things that the OFS might direct one to do. So what have we seen happening? Well, first, the approach that the OFS has taken to deciding that a provider is at risk is not always do we feel that the OFS has applied correctly the test set out in the conditions of registration. The test is that there is a material risk that the provider will substantially exit the market or exit the market completely. We've had the OFS expressing the test as being a risk that the provider might exit, which I'm sure you'll appreciate is a lower threshold than will exit the market. And it's interesting also perhaps that there's no stated time period within which that material of risk of substantial market exit arises. So are we looking at a 2-year horizon, a 1-year, or a 6-month horizon? We've also found that the OFS's focus is, unsurprisingly given what it says, only on students, and often undergraduate students in particular. And that's one of the reasons I began by drawing your attention to the things the OFS must take into account, was to illustrate the point that while important, the students are not the only thing that falls to be considered. And what you've already heard from Matthew and from Neil makes that point rather well. I feel that there are also other creditors and other obligations that the institution has as a corporate entity. The next two comments, I suppose, timing and detail, I suppose, come together. Matthew's already observed that we found the OFS has possibly inadvertently added to the stress and pressure on those working in a HE provider by requiring, under a student protection direction, information of a certain kind and in a certain format, or requiring a provider to take particular steps, all of which take up resource and time, and often the resource and time of the very same people who are looking to secure the institution's future. And you'll appreciate that a provider is required to comply with a student protection direction, and failure to do so will be a failure to comply with a condition of registration, which ironically or obviously will lead to separate regulatory enforcement. Also, at times, the detail sought can involve repetition of work already done, but with a slightly different focus. Now, in fairness to the OFS, I think when these kinds of time and details issue arise and they're explained to the OFS has adjusted some of the directions it's made, perhaps agreeing to accept a different format for information or extending the time within which information is to be received. Also linked to observation Matthew made, and indeed Neil has made, the OFS is not the only regulator, and the Higher Education and Research Act is not the only piece of legislation that's engaged when an institution faces financial difficulty. We've observed many providers are charities, so charity law applies, and indeed the student is not the only beneficiary under the institution's charitable objects. Many HE providers are companies, so the law around insolvency applies, as Neil's adverted to, although of course we have that problem that it's unclear exactly how insolvency works in other types of legal beast. Some of the things that the OF say it will direct a higher education provider to do, for example, compensating students, may well be at odds with other obligations on the governors and trustees. And our experience is sadly that the OFS is perhaps not fully aware of the other legal issues around the corporate structure of the higher education provider. And finally, we've seen some student protection directions that require the HE provider somehow to get commitments from others, for example, other higher education providers. As you'll appreciate, my higher education college cannot compel your university to act or agree to anything. And I suggest that the OFS doesn't have the power to require your university to do something that assists the students at my HE college. So where does this leave us? Well, in the event that you find the OFS engaging with you in connection with student protection directions, be alive to and be prepared to push back on the OFS and the directions it seeks to impose upon you. This is a difficult area, and the OFS, frankly, has limited experience in dealing with such situations. And as a result, I think we see some activity by the OFS which is capable of challenge, and at times very capable of challenge, which is code for probably wrong. So we advise against being too supine in your dealings with the OFS. Now Poppy's going to look at the effect of mergers and collaborations.
Thank you, Richard. As you'll probably be aware, in response to the financial climate at the moment, there's a growing number of HEPs that are considering joining forces to develop meaningful alliances at scale. Now, these alliances can take many forms, from partnerships and joint ventures, franchising models, through to shared services arrangements, and at the most radical end of the spectrum, strategic mergers. With the threat of some universities now facing a potential market exit situation, the OFS has said that it will be publishing some form of guidance on practical considerations for providers thinking about transformational mergers alongside its annual report in May. So strategic mergers are very much on the agenda of the regulator at the moment, and it's for that reason that I will focus on them in this session now. So what do I mean by a strategic merger? Well, essentially it's a planned merger of two or more institutions or organisations that's come about through shared strategic goals and values. There's essentially, from a legal perspective, two types of merger models that are used. Generally speaking, which are referred to as Model A and Model B. Model A is rarely used because essentially what that involves is setting up a new entity or organisation, and the merger partners transfer all their business and undertaking into that new vehicle or organisation. It's hugely time-consuming and expensive, and therefore the Model B route is the most popular merger process that is generally followed, and that involves one institution transferring all its undertaking. That includes its assets as well as its liabilities, staff, students, employees, etc., into the other, and generally the enlarged institution is then renamed. What type of legal process is actually used to achieve that Model A or Model B merger will be slightly different depending on what kind of organisations are actually merging. There's many benefits to a merger for a solvent institution potentially, which may include complementary academic programming and research, expanded geographical footprint, the acceleration of new capabilities, for example, online learning, and enhance shared services offerings and financial efficiencies. However, whatever the rationale for the merger, each one will come with its own unique set of challenges, and they are notoriously difficult to execute and extremely expensive. So invariably, for a merger to actually be successful, there needs to be a significant push factor to overcome these barriers. And those push factors will probably be different for the different parties within the merger, and may well be sort of financial sustainability issues. Two of the biggest mergers in the sector for decades has recently been announced, being St George's merger with City University to form City St George's, and Anglia Ruskin University's merger with Writtle University College. Both of these were planned and strategic mergers designed to take place to take advantage of the economies of scale and to strengthen the offerings of the merger parties. Mills and Reeve were lucky enough to advise St George's and Anglia Ruskin on both of these mergers. So we've seen at first hand how the parties have navigated the issues and the highs and the lows of implementing a merger process. It's too early to tell how successful these mergers are likely to be, as they are still very much in their infancy. But no doubt the sector will be looking on with interest. Now, strategic mergers and alliances are very different to a distressed purchase, and we've heard today from my colleagues about some of the issues with a disorderly market exit. But unfortunately, Mills and Reeve have also been closely involved with more than one university that's potentially facing a disorderly market exit in recent times. And unless there's sufficient contingency planning that's been done, which may be in the form of a market exit plan, a distressed university can find itself in a position where it's required by the regulators to find a partner, and that might be a private partner or it might be a public sector partner that's willing to take over all or some of the functions of that university, probably at breakneck speed. And the burning platform that university is operating from and starting from only serves to weaken its negotiating position. So it makes it much harder to protect its IP, its brand, its students, its staff. Quickly finding a home for X thousand students mid-year, or even on short notice, 6 months or so, is almost impossible and will be extraordinarily expensive on so many levels. As we've heard from my colleagues, the governors are going to be concerned with protecting the interests of the students and the staff, as well as thinking about what its role is in respect of the creditors as well. And the process will be fraught with uncertainties about what the regulators will do to help with the funding and waving through the regulatory consents to allow the merger to take place. So we really cannot see what the value in these distressed purchases will be on the sector overall. If strategic alliances are going to create value, they really need to be carefully thought through. Long-term sustainability means making decisions in light of careful assessment of future risks, and waiting until a risk has manifested to implement a change of direction is just too late. So if not already, contingency planning should be on the agenda at your governing body meetings. And if you're not already do so, we urge you to consider carrying out a structured scan of potential partners that could help your institution achieve its objectives. As a stronger university, would you consider taking over a financially weaker institution? If so, what kind of institution would you be looking to merge with? Would this be a local provider? Or are you looking to expand into other regions? What kind of provider would bolster your capabilities? If you're in a weaker financial position, what partners are likely to give your institution the financial security it needs? And what kind of partner would help you build economies of scale to really strengthen your position? Would you consider diversifying into other areas, for example, selling part of your business, possibly to a private provider or to industry? And how can you strengthen your ties with local FE providers, the business community, and local government? What would your red lines be? Exploring your collaboration options early, no matter what your financial position, may be a tool to help with your strategic thinking and planning. Before I go, if we go to the next slide now, please, Lucy, I just wanted to sort of flag a few of the learning points that have come about from the mergers that we've been involved with, in case it's helpful. So firstly, back to the merger partner, have a structured and systematic approach to finding your merger partner, and think about you know, how you'll discuss the timings for discussing and approaching that merger partner and when that would be right for you, and be bold in your choices. DD, get to know your partner. Cursory DD, once you've chosen your partner, will only miss hidden costs and issues down the line. But know what your red lines are and be prepared to be pragmatic. There's plenty of skeletons in every university's cupboard, so don't get caught up in the unimportant detail. Mergers do take time. I mean, I would estimate at least 18 months, if not longer. And typically they'll start at the beginning, ideally start at the beginning of an academic year. So you'll need to work backwards from that. And also bear in mind that most mergers will have a split exchange and completion as part of the process, so that the merger becomes legally binding on exchange, and then you have a period of time to get everything in place, including regulatory consents, banking arrangements, etc., before completion. They're extraordinarily expensive, so make sure you're realistic about this and do sufficient planning early on, and engage the services of an advisor to establish a joint financial plan early on. Keep your regulators on side and really talk to them right from an early stage about how the merger is going to not just help the university and its students, but also in the wider context, the local community and the wider sector. Consider your comms at an early point and make sure staff and student communications, you know, are carefully planned and thought through. Take them on the journey with you, and make sure you try and think about reflecting any potential mergers or novations in your contracts at an early stage to mitigate potential claims. And then really, almost lastly, personalities. So they are going to be the key as to whether or not your merger is successful, both on an internal basis. You know, think about, you know, key decision makers on your council, on your SMT. How will they work together to resolve difficult issues? How will that process be managed? Are your key negotiators, you know, experienced? And seek help where you can. And importantly, the dynamics between the parties will be absolutely key to the success of the merger. You know, so make sure that, you know, starting with chair of councils, the key council members, the VCs, secretary and registrars, and other senior academic managers. This requires not only some personal chemistry between the key players, but also leadership in the highest order, because it may involve making really difficult decisions that might not necessarily be in your own best interests. And it may involve being able to say, my duty to this institution requires, in this case, for me to overcome my natural loyalty and do everything in my power to ensure a smooth transition to merger with another institution, so that the new merged institution can develop in a new and better way. Mergers have been around for a long time. In fact, most universities have actually merged at some point or at some part of their history. The success of them is very difficult to measure, particularly in the HE sector, because there haven't been huge numbers of mergers in the last few decades. The FE mergers, it's a fairly neutral result in terms of how successful they were. And we know that in the US, there were many unsuccessful mergers in the HE sector over the last few years. And in terms of sort of increased tuition fee revenue and enrolments. But I think it's safe to say we're likely to see more strategic mergers over the next few years, given the current climate. And so hopefully some of this will be useful in terms of planning for those. Thank you, Sarah, back to you.
So thank you everyone. So before we come on to your questions, we just wanted to end on a slightly more positive note. So looking at some of the practical things perhaps that you can do based on recent experiences to kind of prepare for whatever may come in the future. So student protection plans, Richard has spoken about these. Do you know what's in your student protection plan, and does it need updating? It may well not have been looked at since you went onto the register, and obviously we're in a very different environment now. Market exit plans. We understand that there is likely to be some OFS guidance coming out very shortly when they issue their annual financial sustainability report. I think it's a good idea to understand what is in that. I think that's the regulatory direction, and so clearly there will be things that you can do to prepare for that plan, even if you're not legally obliged to provide one. governing bodies. It's critical that they are kept in the loop and kept up to speed, because any major decisions that would be made in this area sometimes have to be made very rapidly. And so you need to make sure that the GB are not just aware of what's going on within their own university, but what's going on within the wider sector, and particularly something of the stuff that we've talked about today. Mergers, I think Poppy's already talked about. Has this been discussed? Do you have your long list? And critically, what would actually your institution's response be if you were approached by another organisation asking to merge? And finally, lending arrangements. Often these have been in place for a very long time. You might have multiple loans across multiple partners. It's a good idea to refresh your knowledge of what's actually in them, the real details of the financial covenants, but also some of the other provisions that might come into play in the current environment that were perhaps never really seen as being that critical before. Okay, so we'll turn to some of the questions. I think the first one I have is for Neil. So what responsibility and personal liability do the directors and executive board members of a university have in respect of their decision making in the event that they make decisions knowing that the financial situation of a university is worse than is known by staff, students and partners?
Thanks, Sarah. Again, subject to the unfortunate caveat that I said earlier about the fact that that this legislation may or may not apply. But assuming that the insolvency legislation does apply, if an HEP is insolvent, which I understand is a controversial term, but it is a statutory term. So either it's unable to pay its debts as and when they fall due, or its liabilities are greater than its assets on its balance sheet, then the company's insolvency legislation provides that the directors' trustees should act in the best interest of all creditors. So you may find yourself in a circumstance where the university or HEP is insolvent and may not be able to satisfy all of its liabilities at any given point. But there is no special, just like there is no special duty at the moment in light of students, there's no special duty in relation to employees. They are a class of creditor. So it's very easy for the lawyer to say, well, you may not necessarily disclose to your employees what the current position is. It will depend on the circumstances, but obviously the danger is if you disclose the position to your employees and that information gets out into the market, then what effect will that have on the provider and its ability to discharge that duty to all creditors? So it will depend on the circumstances, but there is no obligation to inform the employees in particular in relation to the financial position that you find yourself in. It's got to be evaluated on the circumstances and what is in the best interest of all creditors.
Thanks, Neil. Okay, question for Poppy. Talking about further education colleges, several large FECs now turning over 100 million plus. Is there a potential legal path that might be possible for an FEC to merge with an HEC, both created under the 1992 Act, specifically looking at the Luminate model in Leeds?
Thanks, Sarah. Yeah, so I mean, we are seeing more mergers between the FE and the HE sector, as you'll probably be aware. Typically, those structures more recently have involved the FE college merging into a wholly owned subsidiary of an HEP. But there's nothing to say that it couldn't be the other way around, or that you couldn't transfer the undertaking of an HEP into further education college. So we may well see that more. I certainly think going forwards we will see a lot more sort of collaboration, hard and maybe soft collaboration between FECs and higher education providers, and especially as sort of messages we're getting from the government is that universities should be looking at local provision, local benefit to the economies, and that kind of thing as well. So I think there will be a direction of travel in that direction.
Okay, thank you. There's also a question about for charity trustees for HPs, what happens if they all resign? Does the Charity Commission provide some process? I mean, I think the short answer to that is that I don't think that's ever happened. I think probably our view would be that the Charity Commission, I mean, they do have the power to intervene and appoint trustees in the last in the last gasp. And although the OFS is the regulator for charities because they are exempt charities, there is still the ability for the Charity Commission to intervene. So I think our view is that, yes, probably that is the point at which the Charity Commission would intervene. A question for another one for Poppy. Where can you find details of Model A and Model B? You talked about that in the context of mergers. Yeah, unfortunately, it's not sort of wired into legislation. It's guidance that actually came out originally, I think, from the FE side of things. So yeah, no wired sort of law on that as such. But effectively, it's not more complicated than I already described. Thank you. Another one for Neil. Would the student loan company, and I guess by coincidence students, count as a creditor in a market exit?
Yes, they would, to the extent they're owed money and have not been resolved in another way. But yes, they would be a class of creditor. As I say, the general duty is to act in the best interests of all creditors, so they wouldn't come ahead of anyone else necessarily if they're unsecured. But yes, they would be a creditor if they're owed money. Okay. And one final question for Richard. Do we think we're moving to a position where a government would, and also for Poppy, I guess as well, where a government might be seeking to mandate mergers as happened in FE? What do you think the impact would be on individual institutions and the likely success of those mergers if they are forced? Richard, do you want to go first and then Poppy?
Do I think that we'll move to a position where there is legislation that enables a body to do that? I don't, as it happens. I think that the measure of complexity around the legal characteristics of higher education institutions is such that I think it will be difficult for there to be legislation that could do that. But would pressure be brought to bear, financial or other, on institutions, thus giving the feeling that one being forced into merger? I do see that occurring. Poppy? Yeah, thank you, Richard. I completely agree with that. I mean, the other side to that question is, well, if they're going to put pressure or on providers to merge or make it mandatory, there needs to be a clear sort of funding regime behind that, I would imagine, and I can't see that necessarily being committed to. And I think in terms of how successful a mandated or sort of pressured merger would be, much less successful is my view than if the parties come together, you know, and they've really thought through why they want to be together, and they've planned how the merger will take place and what the genesis of it is. So I really can't see them being that successful for those reasons. Okay, thank you, Poppy. Well, that brings us to 11 o'clock, so we'll draw this to a close. Just a reminder, we will be circulating the slides and the recording to attendees. There was also a feedback form. We're really grateful for your feedback on what we've talked about today and if there are any other topics that you would like to hear more about. But thank you very much for coming and enjoy the rest of your day. Thank you.